This is my first opportunity to address this distinguished body. I'm honored to be the 25th Chief Justice of the Louisiana Supreme Court. Many of you were able to accept the invitation to join us in New Orleans for my recent investiture service, and I thank you for braving the cold and sharing that day with us. Thank you for the many warm wishes of congratulations and support. Thank you as well to the legislators who were able to attend our recent ceremony when we commemorated the 200th anniversary of the Louisiana Supreme Court. In recognition of this event, over the past year, the court has held oral arguments in the Cabildo, one of the court's original homes. The court met in Sala Capitula, which was the same room where oral arguments were held almost 2 centuries ago. The court also traveled to Natchitoches, another city where the court used to sit many years ago. The next issue of the Louisiana Bar Journal will be dedicated to the court's bicentennial and will include several articles by historians that talk about this historic event. The court will also be producing a booklet similar to the one that was produced in 1813 when we celebrated our centennial. It will include a transcript of the bicentennial ceremony and other articles of interest. Because of the historical interest, we will also disseminate it to schools and libraries around the state so that citizens and students generally will have a document of this historic event. Our respective 2 branches of government have a history of mutual respect and cooperation. And let me assure you that I, as Chief Justice, will do everything that I can to continue to build upon that relationship. This is one of the reasons I'm glad to continue the tradition of these visits by our court to your chambers for the State of the Judiciary address, and I thank you for welcoming us here this afternoon. Thank you as well for the respect, courtesy, and cooperation that you show our judges, our lawyers, our staff, when we present the judicial branch budget requests and other legislation that impacts the judiciary. We thank you also for your time spent chairing and serving on various court committees that are concerned with judicial reform. We want to extend a special thank you to Senator Ed Murray, who chairs our Committee on House Concurrent Resolution 143, which I will speak about in a minute. We also thank Representative John Schroeder, who does a yeoman's job in chairing the multidisciplinary task force on legal representation in child protection cases. We thank Senator Martini for the work that he did in overhauling our indigent defense system. I believe the mutual respect of our 2 branches is based upon a recognition that the legislature and the judiciary are 2 separate but equal branches of government. Both our federal and state constitutions enshrine this principle of separate but equal, a principle which is meaningless and ineffective without maintenance of an independent judiciary. Although judges in this state are elected, our allegiance is to the Louisiana Constitution and to the rule of law. It is the duty and the responsibility of each judge in this state to apply the Constitution and laws to the facts that are presented without fear or favor. A judge cannot be partisan, despite which way political winds may be blowing. Our independent judiciary is a hallmark of our democracy, and we all should take whatever steps are necessary to respect and preserve this independence. The state's judiciary budget is only about 0.5% of the total state budget, and we rely on this body to provide adequate funding for our branch of government. This guarantees an independent judiciary. It enables the state judiciary to fulfill its constitutionally mandated duties to resolve disputes, and also allows us to continue to work for reforms and improvements in the area of judicial administration. We've worked diligently to return the respect, courtesy, and cooperation you have shown us by the way the state judiciary responds when you call upon us. The court, either on its own or through the Judicial Council, regularly responds to requests from the legislature for information regarding the operations of the judiciary. Some recent examples include the preparation and submission of the 2011 Judicial Council report in response to House Concurrent Resolution that requested the Council to study the necessity of uniform jurisdictional limits on courts and to make recommendations regarding factors that should be considered by the legislature when it acts on these issues. Another example was the submission of the 2010 Judicial Council report in response to a House Concurrent Resolution regarding the need for uniform standards and licensing procedures for local juvenile detention facility. Through its Judicial Administrator's Office, the court also responds to annual requests from the Legislative Fiscal Office for information regarding the fiscal impact of bills that affect us. The Supreme Court is currently in the process of preparing responses to House Concurrent Resolution 143, which is, as I said, a 2011 resolution that requests the court to conduct a comprehensive study of the caseload data and the number of judges in the appellate courts, district courts, city courts, and to determine what changes are necessary to the existing structure of the judiciary. In undertaking this work, the court is looking at filing data, structure, finance, how we use support personnel, and case weights used when evaluating judgeship needs. The court created this 10-member committee to assist in responding to the resolution, and as I said, asked Senator Ed Murray to chair it. Senator Murray is joined by judges, legislators, and citizen members, including Senator Dan Claytor, Representative Nancy Landry, and Representative Katrina Jackson in this work, and they're being staffed by Judicial Administrator's Office. We sincerely appreciate the service and contributions of these legislators. A report on parish courts has been submitted to the legislature, and work on the various other courts, appellate, district, city courts is underway. The Judicial Council has several standing committees that report to you regularly. Chief among them is the new Judgeship Committee and the Court Cost Committee. Both of these committees were established in response to the legislature's request that the council review all requests for new judgeships, the splitting or merging of courts, or requests for new or increased court costs or fees. These are active committees, and we hope they play a critical role in assisting you legislators when you have to consider bills. Over the last few years, the legislature and Supreme Court have shared a concern about the provision of services for court users with limited English proficiency. In 2010, you passed House Concurrent Resolution 48, which urged the Judicial Council to recommend guidelines and rules to the court for the qualification and standards on the use of court interpreters. You may be interested to know that in 2012, the court joined a consortium for language access and adopted a rule entitled Code of Professional Responsibility for Language Interpreters. Based on a national model adopted by many states, This code provides 10 canons designed to increase the standards of ethics and professionalism for language interpreters in Louisiana courts. We're also in the process of scheduling training classes to educate interpreters on selected topics, such as legal terminology and the court system. These classes will end with a written examination that will test interpreters in both English and their second language. If an interpreter successfully passes all sections, he or she will be considered a registered interpreter. A list of registered interpreters will be maintained at the court and will be available to attorneys and other parties who need this service. Once registered, the interpreter will be qualified to sit for a standard certification examination administered in cooperation with the National Center for State Courts. One of the shining stories of the collaboration of our two branches is the operation of our drug courts. In 2001, you allocated funds which enabled the Supreme Court to establish the first drug court and provide oversight and standards. The idea behind drug courts is to effectively use the resources of a community to fight the problem of drug and alcohol addiction. The design of the first drug court was premised upon the ability of a judge, with the help of a drug court team, to provide an alternative to incarceration for men and women who've landed in our criminal justice system because of their addictions. Rather than incarcerate these individuals, they are provided with services. These services include substance abuse treatment and educational components. They are supervised by a judge who has the ability to award incentive and sanctions based upon the performance of the clients. Treatment is community-based, and drug court participants are required to meet with the judge on a regular basis. They are tested regularly and randomly, and they are required to attend various levels of treatment based upon an established system. As of today, more than 14 years after the first drug court, we have 49 drug courts, 29 adult courts, 17 juvenile courts, and 2 new courts we call family preservation courts, where we work with families to prevent children from landing in foster care. These courts serve an average of 2,700 clients a month. They've spent 336,000 hours in skilled treatment sessions, and more than 189,000 drug tests have been administered. At the end of 2012, we provided a new court training. We provided for a new court in the 36th Judicial District in DeRidder, and they started a new adult drug court program there. We've also reached out to meet the needs of those in Beauregard Parish. In addition to oversight, the Supreme Court has recently partnered with the Louisiana Highway Safety Commission to take over administration and oversight of 5 DWI courts to serve those with alcohol addictions. In 2012, a milestone was reached for the Louisiana Drug Court. More than 10,000 clients have now graduated. In addition, we can count 37 drug-free babies for a total of 449. This amounts to savings for us of over $112 million based on the national average study by the National Council of State Legislators. We can also report that 304 clients who were previously unemployed have found jobs. 68 have finished high school and earned a GED. So we suggest that drug courts continue to be an effective alternative to sentencing options in Louisiana. we've been able to reduce our numbers and costs of incarceration, saving taxpayer money and reducing crime and saving lives. We operate a program called a Judicial Ride-Along Program where legislators can visit drug courts in their area and learn firsthand what we do. I encourage you to take advantage of our Judicial Ride-Along Program if you have not done so. Our drug court judges are all volunteers who manage these court dockets and their regular dockets. These judges tell us that their work with drug courts is rewarding work. As justices of the Supreme Court, our responsibilities fall into two distinct areas. Adjudicative responsibility, which means we decide cases that are presented to us, and we also have our administrative responsibility to oversee the state court system and to undertake efforts to improve the court system. Over my several years on the bench, I've had the opportunity to meet judges from all over the state and from all over the country. And I can say without hesitation that Louisiana's judiciary is composed of some of the most committed, knowledgeable, and hardworking judges in the country. These judges realize that staying abreast of the latest development in the law is of critical importance. And to that end, we have a judicial college that operates under the auspices of the Supreme Court to provide continuing legal education for our judges. In recent years, there's been an emphasis placed upon quality and the relevance of judicial education. We have restructured the court with and now have newly revised bylaws, a new board of governors. And with this change, these new board members have worked tirelessly to strengthen the core of the Judicial College. The Board of Governors has presented a plan to the court to increase staffing and to include a judicial educator. The court also recently hired a judicial education program attorney who will assist in developing new and improved curricula for college seminars. The court also, at the college request, recently enacted a rule whereby at least 5 hours of continuing legal education must be from courses offered at the Louisiana Judicial College. One of the many responsibilities of the court is oversight of the legal profession, and it is our duty to do what we can to ensure competent, knowledgeable, and professional lawyers. With that goal in mind, we have recently made some changes to the Louisiana bar exam. Our Committee on Bar Admissions, which is composed of 15 members of the bar appointed by the court, is charged with testing applicants to assure minimum legal competence, and the committee is also duty-bound to study and improve the examination. About 10 years ago, the Committee on Bar Admissions began a review of the process, and after extensive discussion and analysis, we've made some recommendations for change and made changes. In the fall of 2011, the law schools, members of the bar, public, all gave us input, and we then changed the bar exam so that now there's no more conditional failure. Applicants who have already conditionally failed the bar had one last chance to sit for a separate exam in February 2012, and now they must take all 9 subjects of the examination. I don't know how many in the room are lawyers, but for those who are lawyers, you may be interested in knowing that we no longer allow spotting or skipping subjects on the exam because we found that some lawyers were just focusing on some subjects. We've also placed a limitation on the number of times an applicant may take the exam. It's now 5 attempts. The court's second order implemented a compensatory scoring model, which began in July 2012, and the passing score is now set at 650 on civil court subjects, which are weighed twice as much as non-code subjects. The court will be evaluating these changes and taking up additional long-term changes to the bar exam. Another initiative, which I think will be of some interest to you, is that we are partnering with the Louisiana State Bar Association to put into practice what we call a transition into practice model. This is a proposed 2-year voluntary mentoring program, which will be a pilot program in Shreveport, Baton Rouge, and Greater New Orleans area. And the goal will be to provide mentoring to those lawyers who have no persons they can go to ask questions. Mentors will be experienced lawyers who must meet certain qualifications. They must meet with their mentees on a regular basis. They will take these young lawyers to court and introduce them to judges and other lawyers. They will have the opportunity to look at civil and criminal hearings, to participate in a deposition, and generally to be exposed to the profession as a practice. This mentoring program, I think, will be a great benefit to young lawyers, particularly those in small firms and who practice alone and may not have an experienced attorney to advise them. We've also taken concrete steps to increase public access to our judicial system. Access to justice has long been one of my concerns, and we want to be sure that everyone who needs an attorney, particularly with regard to criminal area, that the resources are there for criminal defense. Also, we want to do more in the area of pro se and self-represented litigants. The court created a task force that was chaired by Judge Harry Randall of the 9th Judicial District Court in order to study and draft recommendations on how people can access our courts when they don't have lawyers. The Louisiana District Judges Association took up the mantle and formed a committee that's currently chaired by Judge Lisa Woodruff White under the direction of Judge Randall. And what they have been able to do is assist judges who must handle cases where litigants appear in court and are not represented by counsel. The committee has worked to inform these judges and the general public by providing information, by providing them various forms and resources. This committee is also active in judicial education, has presented seminars to judges at our various CLE programs. Under the leadership of Judge Woodruff White, the committee recently amended the Code of Judicial Conduct to include this directive to judges who were concerned about how they could assist those appearing without lawyers. A judge may make reasonable efforts consistent with the law and court rules to regulate the abilities of all, to facilitate the abilities of all litigants, including self-represented litigants, to be fairly heard, providing that in so doing, a judge does not give these self-represented litigants an unfair advantage or create the appearance of partiality. Secondly, we recognize that jury service is one of the most important contributions in our, one of the most important facets of our court system. However, we also recognize that often the public finds court proceedings confusing. To supplement the efforts of our state courts To fully explain court procedures, the court recently created a committee to study plain civil jury instructions, and they were charged with translating those instructions into plain and understandable language. The committee's draft instructions have been posted on our website for comment from judges and from others around the state, and we will be reviewing those comments. Our goal is to give jurors the clearest instructions possible so that after they have been charged, they're able to do their job, to evaluate the evidence, and to return a verdict. Clear instructions benefit not only citizens who serve, but ultimately the judiciary as a whole. We also continue to make advances in the area of technology. Last year, the court hired its first chief information officer. Mike Evans comes to us from American Airlines in Tulsa. He's only been with the court a few months, but also has already made some progress in reorganizing our technology departments, defining the scope of projects, and implementing new project management tools. A few months ago, we also began accepting court filings electronically. This enables a litigant in Monroe or Shreveport to have the same access to the courthouse as a litigant in New Orleans in the case of an emergency filing. I began my remarks today commenting on the history of the cooperation and collaboration between our two branches of government. I pledge as Chief Justice to continue that cooperation and to maintain open lines of communication with this legislature and with the executive branch of government. In this spirit of intergovernmental cooperation, I'd like to express again my appreciation to this legislature and to the governor's office for consulting with our staff on certain proposed legislation. We've been consulted with regard to mandatory reporting from the courts when adults are prohibited from possessing firearms because of felony convictions. The governor's office has also consulted us about proposed legislation affecting family in needs of services, our FINS program. Continued reform of Louisiana's juvenile justice system is imperative, and it is critical that in these efforts that the welfare of children be paramount. It's encouraging to see the governor's office taking this active role in juvenile justice reform. This legislation seeks to change the parameters of the FINS program so that non-delinquent behaviors such as truancy remain a part of an informal FINS process, and that these children are not stigmatized and do not end up in a juvenile delinquency system. This legislation effectively draws attention to the issue and hopefully will result in a dialogue among FINS stakeholders about necessary reforms. It's obviously not the role of the justices of Louisiana Supreme Court to comment upon the substance of any proposed legislation. Nevertheless, we are truly appreciative of the other branch's willingness to reach out to us when information is needed, and we thank you for your consideration. In conclusion, let me again say what an honor and a privilege it is to appear before you today. We greatly appreciate your hospitality. I look forward to working with you as Chief Justice, and the members of this court stand ready to assist you where appropriate. On behalf of all the members of the court, I thank President Alario, Speaker Cleckley, and all of you, the dedicated members of our state legislature, for opening your chamber to us today, and for your attention to my remarks, and for your unfailing devotion to the people of Louisiana. Thank you.